Good evening, everyone. I would like to begin by acknowledging the Gadigal people of the Eora Nation, the traditional custodians of the land on which we are gathered this evening. I pay my respects to their elders past, present and emerging. My name is Anne Yang and I'm the Executive Editor of the University of New South Wales Law Journal. Welcome everyone to the launch of issue 3 of volume 42 of the journal, our only thematic issue of the year entitled Conceptions of Ownership. We're delighted that you could all be with us this evening at Allens. I would like to especially welcome our keynote speaker, the Honourable Justice Rees of the Court of Appeal in New South Wales. In addition, we are joined by Ross Trinan, a partner here at Allens. We are also joined by Professor Rosalind Dixon at UNSW Law and a faculty of the University of New South Wales Law Journal. I extend a warm welcome and many thanks to you all for being here this evening. A big thank you must also go to Allens, our host for tonight and premier sponsor of the journal. The journal's launch at Allens is always a highlight every year, and having a sponsor like Allens, and the journal for some 3 to 4 decades now, has been vital to the journal's historical and ongoing success as one of the leading academic law publications in Australia. On behalf of the journal and its editors, our authors and reviewers, I thank Allens in particular. I would also like to thank Lauren Kay for her time and effort and support, without which the journal could not be in existence. I would also like to thank the students of the editorial board whose attention to detail and dedication underpin the success of the journal and the quality of our publication. In particular, special thanks and congratulations goes to the editor of issue 42.3, Anna Holtby. Being an issue editor is no easy feat, and Anna has demonstrated phenomenal intellectual leadership and rigour and vision and drive in conceiving of this thematic issue and soliciting submissions for it. And that has been on top of the regular duties of any issue editor. Her leadership, hard work and razor-sharp attention to detail have been incredible assets to the journal, and it's been a privilege to work with her this year. It remains then for me to introduce and hand over to Ross Trinan, partner here at Allens, to welcome us to the firm. Thank you so much, Ross.
Thanks, Anne. Well, I clearly have the easiest job of the night, but on behalf of everybody here at Allens, I'd like to extend a very warm welcome to Justice Rees, to members of faculty, to the editors, and many friends of the UNSW Law Journal. We at Allens are really proud to have been one of a few firms that have been long-time supporters of this journal, although I have to let you in on a little secret. And yes, 30 or 40 years sort of since we started supporting the journal, but I was horrified about sort of 12 years ago to find out that somehow the commitment, let's call it, had fallen through the cracks. And at the time I was heavily involved in recruitment, and I'm a proud graduate of UNSW, and I was horrified that our support of the journal had waned, and so we resuscitated it, and I'm determined, for as long as I'm here at the firm, that it continues, because this is really an outstanding institution which reflects so well on the law students who are involved year to year in bringing the journal together, and continues to reflect so well on the faculty, because this is one of the significant journals published each year, or collection of journals each year in the country, and we think it's so important, both in terms of what it contributes to thinking in the law, but also what it contributes to the experience of students at UNSW. So we're delighted to be long-term supporters, albeit with that hiccup that I disclosed this evening. Don't tell management, because they might use that as some excuse to review longer term support. We'll just keep that as a secret between us. And it's always a delight to have you all in for the launch of one of the issues. So welcome to Allens. Thanks. It's my job now to hand over to Anna Holtby, who has been the editor responsible for this issue. Anna.
Thank you very much, Ross. I would also like to begin by acknowledging the traditional owners of the stolen country on which we meet today, the Gadigal people of the Eora Nation, and recognising their cultural connection to land, water and waters. I pay my respects to their elders, past, present and emerging. I extend that respect to all Aboriginal and Torres Strait Islander people with us this evening. Particularly given the theme of this issue that we are launching today, I feel it must be mentioned that seldom is a species of ownership so often acknowledged and so rarely enforced. As I will mention shortly, this is one of the many reasons that it is incumbent on us to carefully interrogate what we can and should mean in both theoretical and practical terms when we speak of ownership. Good evening, Justice Rees and all of our honourable guests here tonight. Thank you very much for coming to the launch of issue 42.3 of the University of New South Wales Law Journal. Before I invite Her Honour to officially launch the issue with her keynote address, it is my happy task to herald the arrival of the issue with a brief introduction to its contents and to thank people who made this issue possible, many of whom I'm very happy to see here this evening. I'd like to also honour the memory of one of our distinguished authors, Professor Des Butler, who very sadly passed away at the beginning of the editorial process. We're very grateful for his family's help and support, which made it possible to publish his work as part of the issue that we're launching here today. As you will have gathered, this issue of the journal comprises two important parts. The first contains the thematic articles, which include contributions that focus on an area of law of major contemporary importance, and which is the only thematic component that we will be publishing this year under our new publication structure. And the second is the general component, containing the journal's long-standing mainstay of significant legal scholarship on a variety of topical issues. This issue's thematic is entitled Conceptions of Ownership. I almost called it the other 1/10 of the law, but then I remembered the existence of public law and I didn't know how it factored into the calculation. The inspirations for this thematic topic were manifold. The Uluru Statement from the Heart was barely a year old when I began to consider that a thematic issue considering the consequences of denial or recognition of ownership and its contents and significance would be a timely focus for an issue of the UNSW Law Journal. The possible ramifications of driverless cars, the need for increasingly dense residential developments to accommodate a continually rising population, the emergence of online sharing platforms like Uber and Airbnb, not only for ownership rates but also for understandings and new forms of ownership, were becoming increasingly evident and challenging. Meanwhile, data from the Grattan Institute shows that rising housing costs have driven wealth inequality increases in Australia in the past 10 years, highlighting the social and political importance of ownership. Each of the articles within the thematic addresses the challenges to traditional legal conceptions of ownership posed by a range of social, historical, and economic phenomena, such as climate change and the sharing economy, and interrogate how the idea of ownership comes into being and is mobilised by and interacts with law. We're also delighted to be publishing 4 significant contributions to Australian legal scholarship in the general component of this issue. These address topics as disparate as jurisdictional error, workplace investigations, drones and privacy law, and self-represented litigants in the context of domestic and family violence. As you will have come to realise from this discussion and perhaps from flipping through the print journal yourself, putting together a collection of works of this calibre and length takes about an afternoon, give or take. If there's 2 of you, it's a couple of hours maximum. No, in truth, if I thank everyone who made it possible for me to propose, curate, publish, and launch this issue of the journal, we will be here all night, by which of course I mean to say, get comfortable. First, I would like to thank faculty advisor Professor Rosalind Dixon for patiently listening to my halting pitch that, and I quote, "Having stuff is complicated," end quote, and helping to shape it into the thematic that it is today. I also owe both of the journal's faculty advisors, Professor Dixon and Professor Gary Edmond, huge thanks for their support, encouragement, and assistance with various questions and curveballs throughout the process of producing this issue. I extend my thanks also to Professor George Williams for his unwavering commitment to the independence and quality of the journal as Dean of the UNSW Faculty of Law. Next, I would like to thank the authors of each article in the thematic for giving my envisioned theme substance and developing it in new and exciting ways. I thank all of the authors in the issue for entrusting us with their work and for their patience, diligence, generosity, and good humour during the peer review and editing processes over the past year. It has been my great privilege to work with all of you, and I'm delighted to see some of you here this evening. I would also like to thank the author of the foreword to this issue, the Honourable Justice James Edelman, for his generosity in providing thoughtful and considered remarks to preface the articles of the thematic. I'm very grateful to the anonymous peer reviewers who provided the expert commentary on each article considered for this issue that is absolutely critical to the publication decision-making process of a student-run law journal. Without these generous, patient, siloed, for those of you at Allens, siloed means isolated from others, and sometimes justifiably frustrated souls, the UNSW Law Journal simply could not attract and discern the calibre of work that it does. So thank you. I also echo Anne's thanks to our premier sponsors, Allens, Herbert Smith Freehills, and King & Wood Mallisons. I'm particularly thankful, of course, to Allens for hosting us today, which is especially meaningful to me as it is where I completed my summer clerkship and will be returning as a graduate in the not too distant future. Overwhelming thanks must go to the members of the editorial board of the UNSW Law Journal for their hard work, good humour, and willingness to take on last-minute edits. Thank you for giving up hundreds of hours of your otherwise fairly relaxed schedules as students, come family members, come clerks, come friends, come mooters, come interns, come research assistants, come volunteers to ensure that every word, punctuation, and carefully non-italicized space of the journal is positively falling over itself to assist the reader. At least as overwhelming thanks must go to the incredible and dedicated past and present members of the journal's executive committee that I have had the pleasure of working with or learning from during the course of my term. Andy, Amelia, Isabel, Rose, Veronica, Seun, Antonia, Ashling, Eloise, Nick, Shiv, Phoebe, Tom, Inderpreet, Chan, and finally the two steadfastly dependable executive editors I have had the pleasure of serving with, Anne and Lachlan. On a personal note, I would like to thank my mother, Teresa Holtby, who has come a long way here to be here this evening, along with all of the wonderful friends and family who have not only supported me throughout my past 2 years on the journal, but have also taken special pains to make sure they were here this evening. Thank you very much for your endless patience with my repeated failures to be present either physically or emotionally over the past 2 years. Finally, the thanks we've all been waiting for must go to the Honourable Justice Kelly Rees for delivering the keynote address this evening. I'm particularly excited to be inviting an esteemed alumnus of both the University of New South Wales and the UNSW Law Journal to speak to you this evening. Justice Rees graduated with combined Commerce and Law degrees from UNSW in 1991, winning the Sir Kevin Ellis Prize for Best Performance in that combined degree. Her Honour then worked as a solicitor and later senior associate with Mallison Stephen Sharks between 1992 and 1998. During this period, Her Honour also found a spare moment to complete a first-class Master of Law at the University of Cambridge. Justice Rees was called to the bar in 1998 and appointed senior counsel in 2012. Her Honour has served as chair of the Education Committee of the New South Wales Bar Association and has appeared as barrister in multiple royal commissions, including the Royal Commission into Misconduct in the Banking, Superannuation and Financial Services Industry. Justice Rees was appointed a judge of the Supreme Court of New South Wales in 2018, and we are so delighted to have her give up her time to speak to us tonight. Would you all please welcome Justice Rees?
Thank you. I'll just get my props organised. I also acknowledge and pay my respects to the Gumbaynggirr people of what is now known as the mid-north coast of New South Wales, from where I hail. Growing up, I had the benefits of the wealth of their lands and waters, whilst they had and continue to have, on the whole, a different experience. I acknowledge their ancestors and their spirits, their resilience and strength. It is a great honour for me to stand before you this evening and deliver this keynote address for this issue of the University of New South Wales Law Journal, Conceptions of Ownership. I'd like to thank the University for your very kind invitation to give this address, and also for letting me be a tiny part of this august journal last century, when I was on the editorial committee for the 1989 edition, Contract, Death or Transfiguration. The foreword was written by Sir Anthony Mason, then the Chief Justice of the High Court at the time, and it dealt with important developments in the law of contracts. Lightweights such as John Carter wrote on Walton Stores and Marr, Peter Kincaid on Trident and McNeice, Paul Finn on United Dominions Corp and Bryan Pty Limited. The continuities in the New South Law Journal are evident. Property, like contract, is being asked to adapt within the bounds of decided cases so that it continues to be fit for purpose. Comparing these two editions of the Law Journal also reminded me how much things have changed in the legal profession since 1989. If you look at the list of sponsors in the new journal, with the list of sponsors in the old journal, you'll notice the continuity of Alan's involvement in 30 years in supporting the journal, for which I thank the firm very much, and also the seismic change in the face of the firms which work in this space over that 30-year period. If you look also at the editorial boards, that was the editorial board in 1989, and this is the editorial board today. It's obviously become a much more professional endeavour than when I was doing it, and you probably have a much bigger room than we had. But what's also apparent is the cultural diversity in the law faculty these days, which, to use a judicial turn of phrase, is absolutely awesome. My involvement on the Law Journal in 1989 made me realise there was a whole lot of law out there, and there was a whole lot of ways of thinking about it, which aren't necessarily presented in the classroom or in the courtroom, but which provide inspiration, philosophic reflection, intellectual correction, calls to arms, and which find their way into the minds of the profession and ultimately into the law. So turning to the latest issue of the journal, I'm reminded of what then Chief Justice French and Justices Hayne and Kiefel said in Wilmot Grower Group and Wilmot Forests. Care must always be exercised in understanding what the word property, how it's used in legal discourse. It may be used in a different sense, and the very concept of property may be elusive. And that cautionary note was made in the context of disclaimer provisions available to liquidators under the Corporations Act, which is a subject now dear to my heart as a corporations list judge. But this issue of the Law Journal delves into the complexity of the topic of property, and the subject matter of the articles touches upon every part of the law and also reflects social change. The journal articles cover a whole gamut of social issues and adopt the full range of methodological approaches, from the entirely theoretical examination of judgments and commentary to comparative approaches, drawing in primary studies from overseas, to qualitative methods, comparing judgments to the attitudes of those most affected by them. And I hope you don't mind if I drop in some practical examples as we go through these articles, because both from my experience as a barrister and as a judge, just to show you that these lofty discussions have real application in problems that lawyers deal with every day. At the risk of doing the contributors an injustice, I have grouped the articles into three groups, dealing with ancient rights, modern rights, and social rights. But I urge you all to devote to each article the proper attention that it deserves. So looking at ancient rights, I'll just have a sip of water. In Australia, of course, this refers to the relationship that the first peoples of this continent have always had with the land and has been recognised by the colonial system of law only recently and only to a limited extent. In this article, the limited extent, according to the analysis of Professor Simon Young, has been widened by the adoption in the High Court's decision in Akiba and the Commonwealth, which concerned 13 island communities in the Torres Strait. And for those of you who don't know where that is, there's a picture. The High Court adopted in Akiba a broader brush, less technical approach to underlying rights held by claimant groups, as opposed to specific modern exercises of those rights, which are often necessarily narrower because of the passage of time and the intervention of regulatory and private incursion onto Aboriginal land. This is said to have had an effect on the doctrines of continuity and partial extinguishment. Professor Young characterises the decision as a correction and sets out the reasons why an unduly technical approach in some of the earlier cases, Yorta Yorta and Western Australia and Ward, were neither supported by principle nor by the language of the Native Title Act. A comprehensive consideration follows of how this correction has been and will be implemented in lower courts, in the settlement of litigation outside the courts, and its implication for existing decisions. Which brings us to this article. I've put it in the category of ancient rights. It's an article by Fitzpatrick, Campton and Fortuna on the implementation of a Torrens title system in the Philippines and the Solomon Islands. Before considering this article, may I express my support for the Torrens system? I feel I ought at the outset, by reference to one of my last cases that I did at the bar. And it may surprise you to know that there remain many slivers of old system title land property in the CBD of Sydney, forming alleyways between very large and expensive buildings, such as this little beauty. In dealing with a case concerning this laneway, judgment of which is expected on Friday, required us to trace back to the original land grant of Governor Lachlan Macquarie to Quartermaster Hugh MacDonald from one of the original regiments of the colony. And we can see down here the signature of Lachlan Macquarie. From there, I went through a maze of copper plate faded instruments which continually referred to the rites of passage to pass and repass over the land with carts, horse and swine. I then had to work my way through plans in imperial measurements of metes and bounds, which turned out to be not as entirely accurate when we resurveyed the site. And I had to also consider whether, when Quartermaster MacDonald died, whether his wife could even inherit land at all in the early days of the colony, and then when his wife remarried, whether her husband became the owner because he then was a convict. So whilst this is fascinating, and it's also extremely time-consuming and horrifically expensive, and the judge is obviously finding it time-consuming too. Which takes me back to the article. The authors that look at it do a case study on the implementation of Torrens title in the Philippines and the Solomon Islands. Both places have problems with control over the land and the legitimacy of the governments in place, particularly in the Philippines on the more outlying islands where the government in Manila doesn't really have control at all. And it looks at the inability of those nations to comprehensively impose a system of title by registration in the way that we in Australia would take for granted. And the article focuses on the implementation of the doctrine of indefeasibility compared to reality on the ground. And I place this in the ancient rights section because I think it also poses the gnarly question about the implementation of native title in this country, because there's some parallels. Land law in Australia and in the Philippines and the Solomon Islands all struggle with how to incorporate pre-existing rights recognised by customary systems of law. It also appears in these states that introduction of the Torrens system of registration is being used to point to evidence of a rule of law in those societies more generally. But I think that Torrens system relies upon the existence of strong institutions and the rule of law, weak states with low legitimacy are likely to struggle to create the rule of law by implementing torrens, because I think it's somewhat putting the cart before the horse. Before passing from torrens, can I tell you one more little tale, which is why I think it's such a good system. I had a case involving adverse possession concerning a daggy 2-storey 1920s building in beautiful Rose Bay on the harbour. There were 4 units in this block of flats, of which 3 were owned by a mother and her son, and 1 was owned by a strange young man who disappeared in the 1980s. He was thought to have been a drug dealer importing narcotics from Thailand, and it took the police quite a while to gain access to his apartment given the number of locks on his door. Ultimately, they gained access through the toilet window just to see if he'd actually died inside the unit. Over the next 30 years, the son rented out the strange young man's apartment to a series of Ansett air hostesses. Most of you here won't know who Ansett was. He did this to cover the man's strata levies. And finally, 30 years later, the son was in the process of applying for title by adverse possession under this section of the Real Property Act, when it turns out the strange young man wasn't in fact dead, but he'd slid off to Thailand, where he'd only recently died in 2016. Before leaving for Thailand in the dead of night, he'd left a will, leaving everything he owned to 2 young Thai girls from Fairfield, who optimistically came forward to claim their harbourfront unit in Rose Bay. But unfortunately for them, we have torrens. Might I turn to modern rights? When society presents a new set of relationships which appear to be proprietary in nature, such as through technological development, the law has to develop a response. And so some of the articles deal with this. An article by Ritchie and Grigg considers the regulatory response to Airbnb and the so-called sharing economy, although the authors doubted that the term was apt for Airbnb, which in many respects is a commercial enterprise like any other. The article particularly focuses on a judgment of Justice Croft, a single judge of the Supreme Court of Victoria, acting on an appeal from VCAT about an apartment which had been used for Airbnb. And His Honour was able to use existing legal tools within the traditional bounds of land law to deal with the problem. His Honour found that the use of the apartment for Airbnb amounted to an impermissible grant of a sublease in circumstances where the landlord did not consent, such that a possession order could issue. Legislative responses too have built on the existing pillars of land law. They rely on the law of landlord and tenant, strata title, planning law, and the enforcement mechanisms available to local councils to enforce them. In this article, Pappalardo and Meese look at technological advances in the context of the law of copyright, and they've undertaken a very interesting article of individuals who have an interest in the law of copyright, being content creators and users of copyrighted content. And what emerges is a series of values which does not accord with the law as it stands today. Use which is respectful and attributed, even if not consented to, is generally considered to be tolerable and proper by copyright holders, even if it amounts to a technical infringement, such as where music forms the basis of a transformational new composition, or where properly attributed content is shared on social media in the spirit of promotion rather than plagiarism. The authors suggest a response to their findings, a more restrictive approach to awarding injunctions, not sure I agree with that, such that they are only available on cases where actual harm is proved rather than in those where harm is merely presumed because of the infringement. I only say that because it's pretty hard to get injunctions anyway. But it's a very interesting article. And what both of these case studies show is that confronted with new problems created by new technology, and in particular the internet, lawmakers have devised solutions within the 4 walls of the legal regime which already exists. And there's nothing wrong with this. It's likely to promote consistency and comprehension in the law, and it accords with the time-honoured common law tradition of incremental development, although it does appear that the law of copyright has yet to be dragged into a state of coherence in the 21st century. Finally, in this group of articles is an article on the 1908 High Court decision of Dodewood and Spence, which held that there could be property in a human corpse so long as work and skill had been bestowed upon it. The continuing relevance of this case today is that medical samples of various kinds provide exceptions for the general rule that there's no property in a human body, whether living or dead. As the author points out, technological developments, particularly medical, such as biopsies or in vitro fertilisation, mean that such an exception has much more potential applicability than it could ever have had when Chief Justice Griffiths wrote his judgment in 1908. With the starting point of Dodewood, however, Kate Faulkner advocates for an abandonment of a separate doctrine of work and skill, and contends that more modern authorities embark on a multifactorial analysis of the particular facts in exercising a discretion judicially, and they're liable to achieve a more coherent outcome for property in the body both pre and post-mortem. This reminds me of a harrowing case in which I appeared before Justice Barrett as a baby barrister to get orders to take tissue samples from a corpse to determine the paternity of rather a large number of children. Unfortunately, the person had passed away some days before being discovered, and it had become time critical to collect samples. And I had the unfortunate experience of having undertakers standing by at the scene, awaiting an order as to whether and what they could take. And then when I got an order, I found that I had to go back and get a different order to enable us to do what we needed to do. Right, this brings us to social rights. There are two articles in this issue which contain a strident critique of the classical liberal conception of property by reference to a triad of property rights: to use, to exclude, to alienate. And it mainly focuses on climate change, which is also quintessentially a question of modern rights, as it's a problem that's quite recent, has been acknowledged more recently still, and is the subject of sometimes inexplicably intense debate. But it also requires a new, more rational, more relational, social conception of what it means to own property. So the authors of this article, and Ms Johnston is here this evening, entitled Implications of Climate Change for Western Concepts of Ownership, recognises new rights in the Commonwealth carbon credits regime, which is the focus of their study, and they christen a new kind of shows in action. The article also explores the gloss that new environmental regimes place on our system of land law, a system managed by the states, and the consequences of an imperfect implementation by the Commonwealth of a voluntary assumption of rights and obligations which can bind successors in title while not being recognised as an interest in land that can be recorded on a Torrens register. This stuff is real. Last year I decided a case which is not gory, but it's called gory. That's got you tricked, hasn't it, after my last story? In this case, in the estate of Gorey, a will was drafted in the 1960s which gave farming land and personal property appertenant thereto to the wife and the remainder of the estate to the daughters. And the land was in the Murrumbidgee irrigation area in Western New South Wales, where the land was only viable for agriculture because of the irrigation scheme. 50 years passed between when the will was written and when it came to be administered. And in the meantime, New South Wales water rights had been entirely reformed. Ministerial grants of licences attached to specific land had been replaced by freely tradable water rights, and by the time of my judgment, the water rights were much more valuable than the land itself. So I was urged to sort this problem out by defining a new statutory shows in action under the new water rights legislation as either appertenant to the land or not, with the result that it would either pass with the realty or with the personalty, based on the approach in the just terms cases brought under section 5531 of the Constitution. I knew I was in trouble then because I was not one of George Williams' star students. And so I took an easier course and decided that on a proper construction of the will, no, I did it properly. It was intended that the land pass together with everything that could be said to be belonging to it, such that the water rights, although not expressly mentioned, were so central to the agricultural land that they should pass with it. Oh, hang on. Did I move too quickly? There we go. Here's finally the renewal of the old, Lionel Murphy's progressive relational conception of property. I was torn about whether to put this in the ancient rights category, but the author's thesis is that Lionel Murphy's judgment, isn't he beautiful, from his time on the High Court reveal a very modern view of property which departed both from the orthodox position then and now, and may assist judges dealing with novel problems of law. I drew several threads of interest from Baby and Nikias's work. First is the exhortation to be informed not only by the majority opinion, but the whole range of judicial views as potentially informing novel questions of law. Justice Murphy, often in dissent at the time he was writing, has been somewhat vindicated in more recent times by notions of property which are less individualistic. And I think his rehabilitation as a jurist is emerging not so much in property law but in other areas of law. It's said that His Honour's view in this article would today add a richness to discussion of native title. To this, I think, could easily be added climate change. A less individualistic view of ownership may well be necessary to allow climate regulation to coexist with ownership of land as it is conceived today. So, in conclusion, it is gratifying to see the richness of scholarship which this issue represents. My job is somewhat restricted. I apply the law as it is to the facts before me, and appellate courts get upset if I don't. The job of these authors is different, but no less important. They tie together ideas, free from specific facts, unconstrained by what the law is, but what it can be or ought to be, how the law could be more coherent, fairer, and more in tune with society's expectations, using tools not available to judges, such as qualitative research, to actually assess what current attitudes are. The Academy continues to fulfil an important role in criticising, developing, filling in the gaps, and sending new ideas back to the judiciary for use in future cases. I thank the contributors for their efforts in doing so, and I commend the journal to you. Thank you very much.
Thank you very much, Justice Rees. My name is Rosalind Dixon. I'm the faculty advisor, as Anne Hoppy said, to the journal, and I'd like to again pay respect to the traditional owners of the land and to elders past, present and emerging. My job this evening is very easy. It's to give the vote of thanks on behalf of the faculty and especially our Dean, George Williams. So thanks and congratulations first, of course, to Allens and to Ross Drinnen for fighting for all those years for the journal. We really value Alan's support for the journal. One of my jobs as a student was to go around to law firms and persuade them to support the Law Society, and I know how hard and important that work is. So thank you, Ross, to you and the firm for the support for this evening and for the journal. We're very grateful to have alumni who do the kind of work you do in supporting us. The second thanks, of course, is to Justice Rees. I don't think I've seen a better summation of a journal than that. I've been at a number of these events. If you look at Justice Edelman's forward, property has been written about, as he says, for as long as people have been writing about the law, from Justinian to Hofeld. And of course, our authors are to be congratulated for bringing something new to the topic. But I love Justice Rees's taxonomy, ancient, modern and social. And of course, what better way to bring to life those very interesting ideas and taxonomies than taking us to the Thai ladies of Fairfield, to the water fights of the Mullumbimby, to the undertaker standing by for not just one but two orders. You've really done the journal and the authors great credit, and we're really grateful for the attention that you showed to every single one of those pieces and to bringing them together in such a lovely and very entertaining as well as intellectually interesting way. So thank you, Judge. Thanks, of course, to the authors, which is to say that you have a journal that is so rich in bringing new and interesting perspectives to a very old theme. Someone who writes these kind of articles, I know how hard it is, the labour that goes into that. So congratulations and thanks to them for submitting to us and supporting what is such an excellent journal. Of course, the greatest thanks go to the students, to Anna Holtby, to Anne Zhang, and to the team of editors. As Justice Rees said, they're a large team, and all of them work incredibly hard to make this the, if not premier, we can probably say one of the preeminent law journals in Australia. It's an amazingly rigorous journal and a pleasure to read, and it does a great service to the Academy and to the profession, as Justice Rees said, to have such interesting and high quality scholarship for us to all reflect on, read and learn from. My special congratulations to Anna, who has shepherded this from the beginning to the end. One of the things I admire most about Anna is she doesn't take any decision lightly. Every decision is carefully thought out, and if it needs to be remade afresh, she remakes it, and it shines through in the journal in terms of everything in it has been done with care and with thought, and she's brought together an amazing collection of articles. If you look at the general interest component as well, you'll see, it's got jurisdictional error. For the non-lawyers in the room, you could not think of a more technical, long visited topic, along with an article on drones. And it's a hugely diverse journal, and every single one of the journal board and members have contributed to it. They work so hard, and in an era in which we're all time poor and very much limited in our capacity to give beyond the day-to-day, all of those students are to be congratulated, but a special congratulations to Anna for this edition. So it's now my great pleasure to turn it back to Anne to close the proceedings and invite you to stay around and mingle and connect and celebrate what is a terrific event and a terrific journal. Thank you.
Thank you so much, Professor Dixon. I'd like to thank Justice Rees again for joining us this evening, and Ross Drinnen. Like Ros mentioned, please stick around for some more canapes and drinks, and we hope to see you at the next launch. Thank you.